Okay. Good morning.
Good morning.
Good morning. So you know, Mr. Kettler's, is it Kettler? Is that correct? Okay. Is appearing this morning via Zoom. We have two cases on the docket this morning. We have JX 20-00537H. We have two hearings on this. We have a defendant's motion for summary judgment in Portfolio Recovery versus Theodore Simmons. And then we have a trial immediately following that. And then we have a hearing on defendant's motion for, make sure I have it right, pleaded jurisdiction in JX 200082H. I guess we'll hear them in that order. So we'll start with the plea, defendant's motion for summary judgment.
Excuse me,
in
Your Honor.
537H. Yes, sir.
We have three cases here.
No, we have two cases and one case we have two hearings.
Yeah, we have, who is the attorney appearing for?
He's appearing for both cases, 537 and 82. Is that correct, Mr. Cutler?
Okay, if he's appearing for,
No, we're gonna let Mr. Simmons start this morning. It's his motion. We'll let you respond to him at that time. Okay, Mr. Simmons.
okay, you saying we're hearing the summary judgment, no evidence summary judgment.
Your motion.
Okay, but first of all, the plaintiff never responded. So the plaintiff must respond. Never served the response on me, never served one on the court. And today, he had to at least have that served 7 days prior. A motion for summary judgment, this is a no evidence summary judgment. It's not the time, it's based on the pleadings of the paper. The plaintiff has not responded to the no evidence summary judgment. In the law, the rules only permit the court to grant the summary judgment unless the plaintiff responded with admissible evidence to show that. Has not done so.
Okay, so you're asking the court grant it because he hasn't.
The rules in a court case law mandates that. They never responded. The court don't have their response. It was served on certified mail.
Okay. Do you have a rule book, Texas Rules of Civil Procedure book? Texas Rules. That's the track of the manual. Okay. I didn't bring mine with me. Mr. Kettler, did you want to respond to that?
He can only respond.
Even though Mr. Simmons has filed a motion, I'm looking for some sort of basis for why the no evidence motion for summary judgment is being granted, because the basis of the no evidence motion for summary judgment is
If there's no motion, we'll file.
have admissible evidence. And so,
Well, we're going to trial here next.
Uh, oh, Lord. Fraud on the court.
exactly why he could not submit documents for the trial.
Your Honor, I'm gonna have to object to a counsel. A counsel is misstating the law. A no evidence summary judgment places the burden on the plaintiff to come forth with admissible evidence. In the rules of justice court, just like any court, provides summary judgment motions. He can quote and misquote rules all day long. The law of the case of summary judgment. Under Texas Rules Civil Procedure 168, it says even in justice court, one can bring a motion for summary judgment. It was served on the plaintiff counsel. They fail to respond. The only way they can respond, the fact that he's attempting to respond verbally, he needs a motion before the court. He hasn't responded. The law says when they fail to do that, it must be granted. That's just the law.
Can you point to the rule?
It's in the motion, Your Honor.
Well,
It's in the motion. My motion is, y'all have the motion. It's been
I
filed.
have a motion to point to the specific section you're citing as law that it must be granted.
Your Honor, I'm gonna have to object to you as well. You know what the law say. You know what the
No,
rules
sir,
say.
I'm waiting for you.
You know, you can't be, you acting as a advocate for the plaintiff. No plaintiff is here. The attorney is here.
Sir,
He
all
can't
I'm asking for
testify.
you to do is cite the law that you said you stated in your motion.
Do you have a response from the plaintiff?
I do not.
Okay,
Where's the rule require that I grant the motion when there's no response?
Your Honor, it's in the motion. It's Rule 16X AI. Please read it in full.
No evidence after adequate time for discovery.
Texas Rules Civil Procedure 166 AI.
Okay, so he's pointing out 166 AI, which says, after adequate time for discovery, a party without presenting summary judgment evidence may move for summary judgment on the grounds there's no evidence or one or more essential elements. But you didn't do a motion for discovery.
Your Honor, discovery does not. It say after adequate time. In other words, you don't have to move for discovery. If the case has been pending for over 6 to 7, 8 months and the plaintiff or the defendant never moved for discovery, that is adequate time. You don't have to move for discovery.
And what general issue of material fact are you raising?
Your Honor, my motion, I don't have to raise it. The plaintiff must raise it.
Okay, or please do not yell at me. Okay.
Well, you sitting up here being a proponent.
No.
You trying to circumvent the law.
Okay, I'm gonna give you your first warning. Please do
Well,
not-
you can give me a warning, but you're in violation of the law.
Mr. Simmons, I've not ruled on your motion. I need you to calm.
I'm hearing what you're saying.
I want you to act polite and respect.
I am collecting light, but you're not going to commit fraud up on me and violate the law. You took an oath. That's a plaintiff. And if even after this,
Okay, Mr.
there's a trial, there is no plaintiff here.
Simmons, we're gonna take a break and let you cool down.
You don't have subject matter jurisdiction, Your Honor.
I've already ruled on that motion.
No, today you say it's a trial after this summary judgment. There is no plaintiff here. You can't act as a judge without two parties being here.
Constable, if you can escort him from the courtroom.
Oh, you can escort me from. Can't talk. I'm here to litigate. I have a right to litigate. Federal law. Okay.
mentioned you and the first judge. You and I have never met other than the other time we were here. I don't have any position in this case, all right? So please don't yell at me and understand that I don't know this guy. I've never met him before this hearing, really, and the other hearing we had. So I have no position in this case. I just don't want to be yelled at. It's fine for you to be upset and animated, but understand that I am not a party and I do not have a position, okay?
I understand you don't have a position, Your Honor, but it's a
so I have
motion.
to hear from both sides, so understand.
Okay, but here's the problem. The plaintiff must respond to the summary judgment because the burden is on every plaintiff to produce enough evidence, and it must be authenticated. Okay, so once I move, the no evidence summary judgment is well known in Texas, and it's only for Texas. It's going to be used in Texas. So once the defendant moves for no evidence, the defendant doesn't have to produce absolutely anything. The burden is on the plaintiff. It shifts, and it says once that is found, the plaintiff must respond to the no evidence summary judgment in writing. There is no motion before the court. My motion is here. All the court can do is either grant it or deny it because the summary judgment is not for arguments. It's on paper. It's thorough. It's not a hearing. It's thorough.
Okay, all right. Mr. Kettler, you want to respond?
Yes, Judge, I'd like a little bit of clarification, just a quick summary here. Like I said, I had a chance to read the motion that Mr. Simmons had filed, and one of the requirements under 166 AI is that the motion must state an element to which there is no evidence. So that's the main issue that we have.
Once again, Your Honor, I must object. The plaintiff must respond in writing. That's the rules. No, I will not object. You have to respond to the no evidence summary judgment. It was served on you. You haven't gave a valid reason, and you can't present evidence nowhere. You're not the plaintiff. You don't have standing. An attorney cannot testify and prosecute a claim. It's a deprivation of due process. If you claim you have evidence, you can't authenticate it. Powell versus Van Roe McDonough is controlling in this case. If you intend to use a business record, you better have somebody here that I can question. That's a part of due process.
Your Honor, I'd like to respectfully ask the court to take judicial notice of Rule 7, Texas Rule of Civil Procedure. The attorney may appear on behalf of the plaintiff.
I'd like the court to take judicial notice that in order for a court to adjudicate any matter, there must be a controversy, there must be a plaintiff and a defendant. This is a no evidence summary judgment motion, and the plaintiff has failed to respond in writing. You cannot have a summary judgment hearing and he try to respond verbally. It must be in writing because you have to serve it on me as part of due process. The due process is due today is for the court to follow the law under Texas Rules of Civil Procedure of no evidence summary judgment 166 AI and dismiss the claim because the plaintiff had nothing before the court that's competent, that's a contract, the assignment of a contract. It's not here.
Okay, so he raises a point. The court does not have a contract, an assignment of a contract in this jacket. Mr. Kettler, the court has no evidence that your client has a contract or an assignment of a contract. There's nothing in the jacket that would reflect that.
Your Honor, in the jacket, is there a bill of sale?
No, sir. No, sir, there's not.
Your Honor, even if it was a bill of sales is not a contract.
Mr. Simmons, if you could stop talking there's nothing in there. Okay. All right, so based upon that, the court's going to grant Mr. Simmons' motion for no evidence summary judgment, and it's going to be a plaintiff take nothing judgment in that case. All right.
Okay.
Mr. Simmons, you prevailed in this case. I will issue an order that reflects it and mail it to all parties. Okay. So, we are moving forward on JX 2082H. Do y'all need a minute on this case? Okay, so give me just a second. This is Portfolio versus Theodore Simmons. This is the subject matter jurisdiction motion on this case. Let me just confirm it.
Judge, could we go back really quick to the one we just heard with the state now?
Yeah.
That's over with.
Okay, I want to go back and double check one thing that Mr. Simmons requested as for the motion.
Okay, understand I'm not going to revisit the judgment of the court.
Okay, all right, that's good.
Okay. If you want to get a copy of the jacket or come down to court, you're welcome to do that. I'm not going to revisit that. Thank you. Okay, so on the motion for defendant's lack of subject matter jurisdiction, Simmons versus Portfolio, Mr. Simmons, your motion.
Yes, in order for the court to have jurisdiction, it must have subject matter. It must have truth. The plaintiff, I was served, the defendant was served. But in order for a court to hear a case, it must be a controversy. The plaintiff alleged a breach of contract by way of assignment. The court doesn't have it. That's the subject. There's no controversy. There's no contract. What the plaintiff seeks to bring through his attorney is have an attorney come up in here and say, oh, this is what this is. He can't authenticate that. That's a violation of law. Number two, because the court has not heard from a competent fact witness or even from the plaintiff, the court cannot adjudicate or even rule on something because there is no controversy. In order for the court to have subject matter jurisdiction, a controversy must exist at every stage of a proceeding, at every stage. And today we have an attorney saying, oh, I can appeal. But when subject matter jurisdiction is challenged, there must be evidence, testimony. And my testimony today is, I don't have a contract. There is no controversy here. There is no assignment. If it is, where is the plaintiff? Where is the witnesses?
Is that all?
That's it.
Okay. So I just want to make sure we're clear. To me, a subject matter jurisdiction is the court's ability even to hear the case. So, for example, this court could not hear a probate case, could not hear a child case, could not hear a criminal case about a Class C, could not hear a divorce case. So I guess, are you saying to the court you cannot hear
No,
a contract?
I'm saying that the plaintiff lacks standing. See, standing and subject matter jurisdiction must coexist. See, if you don't have standing, the court don't have subject matter. So the plaintiff at this juncture don't have standing because the plaintiff said, oh, we got a bill of sale. Well, a bill of sales is not a contract.
So you're saying the standing itself is what produces the subject matter jurisdiction issue?
In order for the court to have subject matter, there must be a standing for a plaintiff to bring a cause of action. There must be a complete two things, a plaintiff and a defendant. Otherwise, there's nothing for the court to adjudicate.
Okay. All right. Thank you, sir. Let me hear from Mr. Kettler. Sir?
Pretty much so, again, it sounds like what Mr. Simmons is getting at, please correct me if I'm wrong here, is twofold. One, that, again, you're claiming that I cannot appear on behalf of my client. I can appear on behalf of my client according to the rules of procedure, rule 7. Second is that you're claiming that there's really no basis for the plaintiff to be able to proceed. Right now, as far as subject matter jurisdiction goes, I mean, this is a controversy that's below $20,000, and the title is solid, still below $10,000 that the plaintiff increased on September 1st. And based off of that, the plaintiff recovery, they do have standing and basis to proceed with the case.
Okay. All right. Anything else?
Yes, Your Honor, I just want to be clear. Counsel is saying he's appearing. My question to the court or to the attorney, are you testifying?
Not today.
Or are you attempting to authenticate any documents?
That's not what the motion is about.
That's what subject matter. See, the thing about subject matter, like I said, Your Honor, you can limit it if you want. But the law is clear. In order for a court to have subject matter, there must be a plaintiff that has standing to bring a claim. A court cannot say, oh, we have jurisdiction because today there is no contract. So what do this court proceed on? What's the controversy? No contract, no assignment of a contract. What plaintiff lawyer keeps trying to do, and it's held in Powell versus Varro McDonald, the Fifth Court of Appeal, that's precedent, it's binding on every court. Brother, you got a bill of sales, which is a part, allegedly, of the business record. You must be able to bring somebody in here to authenticate it where I can cross-examine. Affidavits can't even be used in a trial in a contested matter. Violates due process. I rest.
Okay. Mr. Kettler, anything else, sir? Okay, the court's going to deny the defendant's motion for subject matter jurisdiction, and we can set this one for trial. Are you back in court anytime soon, Mr. Simmons? Anytime you're going to be down here?
What do you mean?
I didn't know if you had anything going on.
Rain, sleet, or snow, I'll come.
Okay, so you don't care about the day.
I don't care about the day.
Do you have any other cases before the court that are going to
We
bring you down here on any day?
Our cases in here on a pretty consistent basis.
Okay, we can set it for whenever. Okay, all right, thank you for your time today, I appreciate you. Oh, no, log off. Thank you.
Okay,
There you go, okay.
okay, that was.
All right, let me get your orders.
Okay.
Do you have word on that, just so I can do it from there? Okay. Hey, do you want to have a seat? Oh, I don't know how to use it. Yeah, I like it.
What is the deal with 659 J? It's supposed to have been the trial date today too for that. J liquidation.
We have a trial date
I
on?
can answer that question.
Oh, okay.
They are dismissing that case.
Well, where's the?
I haven't-
Judge Jones is not supposed to be signing that, signing.
No, they're gonna stop it to the date.
Well, they didn't
No,
show
we have
today.
a trial now.
This today. This they didn't show.
Where is it? Go get me the jacket. Yeah, they can't pull it that way. They're not prepared for trial, we need to move for it. Okay,
What?
yeah, can you go see if there's one on the jacket? On the fax machine right now? I didn't realize that, Mr. Simmons, I'm sorry.
It's okay. I apologize for my action. I'm my advocate, and I gotta, advocate for myself.
Yeah,
And I just understand the inherent biasness with pro se litigants, but I have a federal right, so,
You're exactly right, you should be a voracious advocate. But you really don't need to yell. You're bright enough that you can prevail on the merits, so take it and win with it. Oh, I do not know. Thank you. Okay, that's not a motion. That is, that's my legal assistant. Okay, so this one is, okay, all right, let's, we can either get him back on the phone or call the hall and dismiss the case. It's not dismissed with prejudice, though.
Well,
That's the JH.
well, if they didn't show,
It's not dismissed with prejudice.
well, this, I mean, you don't have to.
Dismiss it, but it's not with prejudice.
They can do it all day long, but but what I'm saying, if they didn't show the proper thing, is, I mean, you could
It's
dismiss.
a dismissal without prejudice.
Well, that's fine.
Okay, that's what I'll do. All right, we'll dismiss it. Why did you call the ball on this one case for me? Yeah.
Alarm?
JH, whatever, they're not here. We know they're not here. Yeah. Okay, if I print this, where does it print here? Right here. It does, okay. And it says printer.
Yeah, that's it.
Okay. Oh, okay. Huh?
They did.